Time now. Will now request Gary Bourne to address the audience. Thank you.
Thank you so much, Hiru, for that very kind introduction. Thanks also to the India Arbitration Forum for having me here this evening. And perhaps most importantly of all, thank you. Thank each of you for coming here to listen to me. Some of you I have to thank particularly because I think you listened to me earlier today, and I'm sure, at least to some extent, you're tired of that, and I apologize for your having to hear me yet again. I think, though, I'm going to change the focus to some extent of my presentation and the nature of my comments. This afternoon, throughout the course of today at the SIAC annual conference, we had a distinctly practical focus on arbitration. We looked at how, under the SIAC arbitration rules, and you'll forgive me a small commercial break here, we conduct arbitrations efficiently, cost-effectively, practically, pragmatically. My comments today, for those of you who have already heard me this afternoon, are not pragmatic, they're not cost-efficient, they're not expeditious. Instead, I'm going to focus on theory, because this is a forum. And what I thought I would talk about is the right to arbitrate. And because that's a little esoteric, I will need to develop this right to arbitrate over the course of my remarks in the next, I think, 20 minutes or so that I've been allotted. Now, we all know, Hiru mentioned, that arbitration, international arbitration in particular, has become a preferred means of dispute resolution. We can see evidence of that all around the world. We can look at the institutional caseloads at SIAC, for example. Our caseload has been going steadily up year on year. We can look at the caseloads of our competitors, the International Chamber of Commerce, the LCIA, what have you. All of their caseloads increase. Arbitral institutions, which 2 decades ago barely existed, ICSID, the International Center for Settlement of Investment Disputes, and had a caseload of under one a year on average, one arbitration a year, now are recording in the hefty double digits. And it's not just in the number of cases, but it's the size and quality of cases. One sees that the size of disputes increases from being small matters to being very large matters. The UCOS arbitration award against the Russian Federation, $50 billion just earlier this year, is a little bit out of the ordinary, but it gives us some sense of not just the number of cases, but the magnitude of the disputes that are being submitted to arbitration. At the same time, one sees not just ordinary commercial disputes, which was the historic bailiwick, if you will, of international arbitration, but instead a whole range of new types of disputes: sports arbitrations, investment arbitrations, commodities, insurance, a whole range of different sorts of disputes, including even now class action arbitrations and the like, which historically were matters for exclusively national courts. The commitment of commercial parties to resolving their disputes by international arbitration, by arbitration of any sort, is in part because of the benefits that the arbitral process promises and hopefully in most cases brings, namely an efficient, neutral, cost-effective, commercially sensitive, and above all else perhaps in the international context, enforceable means of dispute resolution. Because of the New York Convention, the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, with 156 contracting states party to that convention, both international arbitration agreements and international arbitral awards enjoy a sort of global currency. They are enforceable in all 156 contracting states around the world by virtue of the Global Constitutional Charter for International Arbitration, the New York Convention. And equally, arbitral awards, once they have been obtained, can be enforced. They're portable. They can be enforced around the world in all 156 contracting states. And it is because of that enforceability, that commitment of states around the world to the arbitral process, that arbitration, international arbitration in particular, has enjoyed such substantial popularity over recent decades, over recent years. That said, we can't lie on our laurels, and one must remain vigilant. One must remain vigilant in part because history always is cyclical. History is always cyclical, including with respect to judicial attitudes, to some extent even legislative attitudes towards international arbitration, towards arbitration. There has been a history of judicial hostility in many countries, and I'll speak a little bit about this in a moment, towards arbitration, often focused on the notion that arbitration is a sort of second-class justice. It's a kind of rough justice that doesn't really accord with the rule of law. It deprives, in particular, citizens of their rights, their individual rights of access to the courts, and it deprives the legal system of the legitimacy and the correctness of judgments decided by national courts. And that sort of hesitance, that sort of skepticism about the arbitral process is something that has been recurrent throughout history and that has led to criticisms, and what I'm going to read from now goes back a century and a half ago to the 1840s in the United States, to one of the great American jurists, Joseph Story. What he had to say is something that is reflective not just of the 1800s, but even of 2012, 2014, 2015. It is a sentiment, an attitude towards arbitration which is recurrent and which demands, as I've said previously, vigilance on the part of all of us in the arbitration forum, in the arbitration community, because these sorts of critiques can't go unanswered. They must be responded to. They must be taken seriously. This critique was as follows. Joseph Story said as follows. Now, we all know that arbitration at the common law, arbitrators at the common law, possess no authority whatsoever, even to administer an oath or to compel the attendance of witnesses. They cannot compel the production of documents and papers and books of account, or insist upon a discovery of facts from the parties under oath. They are not ordinarily well enough acquainted with the principles of law or equity to administer either effectually in complicated cases, and hence it has often been said that the judgment of arbitrators is but rusticum judicium, rough justice. And the consequence that he drew from that was that agreements to arbitrate were not enforceable. They were valid, but they were not specifically enforceable, rendering them effectively useless in the United States for some 80 years. This position was not an outlier. This was not unusual. The English courts adopted similar views, only being rescued by statutory instruments. In France, a classic decision, also ironically, in the 1840s. The Americans and the French don't usually do anything similarly. In this case, the French Court of Cassation took precisely the same view in a decision called Prunier versus Alliance, in which the Court of Cassation declared agreements to arbitrate future disputes invalid and unenforceable on the basis that persons that were appointed as arbitrators might not, quote, be able to deal with the matter and worth the confidence the parties would entrust to them. Again, the basic notion that arbitration provides rough justice, not real justice, and thereby compromises both the rule of law and individual rights of citizens. This is a serious critique, one that the arbitral community must answer. And the answer to it, I would suggest, and that's the principal focus of my comments this evening, the answer to it is that has it exactly backwards. It's exactly wrong. The right to arbitrate is a fundamental right of citizens and is as important to the rule of law as other rights of citizens. Just as citizens have the right to marry whom they choose, the right to contract as they wish, the right to associate as they will, so citizens have the right to settle their disputes with their contracting parties, with their spouses, with those in their associations as they will. At the end of the day, disputes, the way to fix disputes, to mend relationships, is a fundamental aspect of individual rights, individual autonomy, and preservation of those rights is fundamental to the rule of law. And that is something that I think appeals not just to our common sense of justice, but it's something also that one sees, just as one finds recurrent judicial hostility to arbitration through the ages, one also finds recognition of this thing, this right to arbitrate, as I have called it. And what I'd like to do in the time remaining is to refer to some examples historically in diverse cultures of this right to arbitrate, which is, I would suggest, so important to the fabric of our legal culture today, both here in India and elsewhere. I'd like to begin with going back to France, where, as I mentioned previously, the Cour de Cassation held arbitration agreements invalid on the basis that they compromised the rights of citizens. That, in fact, in the 1840s, was a dramatic about-face from the 1792 Constitution of Year One of the French Revolutionary Republic. That Constitution of Year One, in fact, contained within it a constitutional right to arbitrate. In the Constitution, the French regime guaranteed to citizens the right to resolve disputes by persons of their choice, a constitutional recognition of the importance of the right of individuals, the right of businesses to resolve disputes as they would. Subsequently, after the Prunier decision that I have referred to, France again came back to the fold, came back and saw the light, if I can put it that way, and in the Geneva Protocol in the 1920s, adopted pro-arbitration rules of interpretation, pro-arbitration rules of validity, and more recently, France has been in the forefront of pro-arbitration legislation giving effect to international arbitration agreements. In Germany, a similar dynamic occurred. In 1877, the Prussian Code of Civil Procedure adopted a very pro-arbitration approach to both international arbitration agreements, domestic arbitration agreements, and awards. It was a legislative regime that looked very much like the UNCITRAL model law that we're familiar with today. Come the 1930s, with the Nazi regime, there was, in place of the 1877 Commercial Procedure Code, something called the Reichsguidelines regarding arbitral tribunals, which declared, and I'll quote from these, from a state political point of view, a further spread of arbitrations would shatter confidence in state jurisdiction and the state itself. The basic philosophy of the Nazi regime at the time was that individual autonomy, individual businesses, individual people deciding how they wanted to resolve their disputes between themselves was a threat to the totalitarian regime and therefore should be forbidden. The good news is that by the 1960s, the German liberal court regime that had replaced the Nazis after the Second World War adopted exactly the opposite point of view. And in a very well-known German decision, making use of guarantees of individual rights in the German Constitution, the German Basic Law, the German Supreme Court announced the following: the right to agree upon submitting a matter to arbitration is contained in the fundamental right of freedom of contract under Article 2. The restriction of state jurisdiction occurring as a result of the agreement to arbitrate is a result of the parties' exercise of freedom of contract. A basic recognition of the importance of the right to arbitrate to any constitutional regime, to individual rights, to the rule of law itself. And although I reminded you of Joseph Story's views, negative views about arbitration and rough justice in the 1840s, come the 20th century, U.S. courts adopted a very different viewpoint. They said, and I'll quote from a Hawaiian Supreme Court decision, the recognized autonomy of parties to enter into an arbitration agreement is directly correlated to and stems from the constitutionally protected right of freedom of contract. And the United States, in the Federal Arbitration Act, adopted exactly the same attitude, giving effect to agreements to arbitrate. There have also been international tribunals, the ATA versus Jordan Investment Arbitration Award and the Saipan versus Bangladesh Arbitration Award. In each case, investment arbitral tribunals concluding that national court decisions denying effect to arbitration agreements constituted denials of justice in violation of bilateral investment treaty guarantees and of customary international law itself. This corpus of decisions from widely diverse national jurisdictions, from international tribunals, in my view, reflects an emerging right to arbitrate, reflective of the importance of individual autonomy in the resolution of disputes ultimately between individuals who every constitutional regime that you look at guarantees those individuals the primary voice in how their disputes ought to be resolved. At the end of the day, the response to those who would criticize arbitration as providing second-class justice and undermining individual rights and the rule of law is that those critiques have things precisely backwards. In fact, it is arbitration, a recognition of the individual autonomy of citizens to resolve their disputes as they think best, to mend their relationships in the manner they think wisest. Recognition of that autonomy does not undermine the rule of law, it advances the rule of law. It does not undermine the rights of citizens, it advances the rights of citizens. And we in the arbitration community ought have no hesitation to stand up and say precisely that to the critics of what it is that we do. Thank you.